I gotta say that I am blown away by the support that I've received from concerned citizens that maybe weren't even looking at this issue, with the exception of Ward, before this in a serious way, and they have come forward and dedicated, I'm going to say full time every week since we got together on this issue. And so Randy and Nancy and Ward and all the people that have been advising us legally, I think they really deserve our thanks on this. Randy said I'm the representative of the Sierra Club. I'm what they call the Conservation Program Coordinator here in the state of Tennessee. So I work from Memphis all the way to Bristol, Tennessee, working with communities that want to protect their water and their air from environmental degradation. In the wintertime, I have the joy of going up to Nashville and working with our legislature to try to protect our environment, or at least not stop protecting our environment. And this case came up, and it's been consuming a lot of my time, but I think that it is one of the most important things that we have going for us. We have an aquifer here that can provide water, clean drinking water to our community for hundreds of years to come, at least, if not thousands, if we take care of it. But right now, we're in a realm of a lack of regulation, a lack of coordination between states and counties as to how we're going to manage this resource and protect it for future generations. And this is opening the doorway for us to enact good public policy that's going to lead to sustainable management of our drinking water resource here. And I'll also say, for the resource that attracts industry to our town. Medical community has come to Memphis. One of the main reasons is because it doesn't cost them very much to turn our aquifer water into medically pure water for research purposes, for medical purposes. This is why they come. In other cities, I've seen statistics that show that where it costs $1 to take a gallon of water to medically pure in Memphis, it costs as much as $15 to take it to medically pure in places like St. Louis or Detroit. And that's why we're seeing an influx of people moving to Memphis to be a part of our medical research community, and I think this is something that we need to build on. This situation really got its start in 2006. The Sierra Club and the National Parks Foundation filed a notice of intent to sue the state of Tennessee over the Tennessee Valley Authority over the sulfur dioxide pollution that was coming out of their coal burning plants across the TVA service area. That's 7 states, Tennessee being the main one. The Environmental Protection Agency saw merit in that suit and joined in, and then a bunch of states to the east of us joined in with that because our sulfur dioxide was raining down on their streams and their forests and degrading their natural environment. And the result of that lawsuit is what we call a consent decree between the EPA and the Tennessee Valley Authority that said that Tennessee Valley Authority needed to shut down its dirtiest coal burning power plants and make decisions as to whether they were going to make investments in pollution control technologies at a slew of other plants by the year 2018, and the Allen plant was one of those facilities. In 2014, the Tennessee Valley Authority issued to the public, and Randy was kind of alluding it, they kind of try to sneak things through, like avoid public participation. The Wednesday before the 4th of July weekend in 2014, they put out a public notice saying, we want the public to comment on our plans to shut down this coal plant, and the options were to replace it with a clean natural gas plant, which is what they chose to do nothing, which wasn't really an option because there was a requirement to have spinning generation of electricity in our area. We argued that yes, you should replace this coal plant with a cleaner burning natural gas plant, but we suggested that it be smaller because we knew that there is a company called Clean Line building a direct current power line across Arkansas from Oklahoma that's going to bring us 3,500 megawatts of wind power as of 2020. And so we suggested that it be a smaller plant which would require less water, and that we make purchases of that wind power, which by the way is being offered to us below the cost of generating power via coal or natural gas at a fixed rate for 20 years right now. And TVA has not chosen to purchase any of that fixed rate below cost of generation power. Kind of a side issue. They settled on building a 1,000 megawatt natural gas plant here, and they said that they were going to use, they explicitly said they were going to use in this environmental assessment document, wastewater from the Maxon treatment plant, which is literally next door to their new natural gas plant on the Frank Pigeon Industrial Park. Everybody thought that was a good idea, and you know, didn't make a big deal of it, but I know that in conversations that we were having as we were putting together our comments on it, everybody's like, hey, that's very progressive. At the same time, TVA said they were going to do the same thing at a plant in Kentucky called Paradise. TVA has now reneged on both of those plans to use wastewater. Here in Memphis, they decided, we don't really know when the decision was really made, but they put out a technical document called the Supplemental Environmental Assessment in April of 2016. We learned that they were going to do that in January of 2016 and expressed our interest in commenting on that also. They had asked for our comments on the original EA in 2014. We submitted more than 1,500 comments, citizens around Shelby County, and highly technical comments from the Sierra Club and the Southern Alliance for Clean Energy, the Southern Environmental Law Center. You know, this was not something that we, you know, did lightly. When they came out with their supplemental EA, they chose not to put it out to the public. Now, technically, under the National Environmental Policy Act, they didn't have to. But again, they had voluntarily done so on the original document. We were a little miffed that they didn't ask our opinion about their change of mind. They went to the United States Geological Survey and they produced a very slim document that said, well, this isn't going to take so much water that it's going to have any impact on the volumes of water that are available in the future. But several times in that document, it pointed to the fact that drawing that much water from one location could lead to drawing lesser quality water or even contaminated water from the superficial aquifer, the aquifer that's actually associated with the Mississippi River, immediate groundwater, into our drinking water aquifer. And there's a lot of science behind that. What we used to call the Groundwater Institute at University of Memphis, which is now the Center for Applied Earth Sciences and Engineering Research, and the USGS have done numerous studies that show that where we're drawing a lot of water out of the Memphis sands, it has resulted in drawing water down through thinnings or holes, or people call them breaches in the confining clay layer that protects our aquifer from the water above it, into it, and just below the TVA plant, just south of the TVA plant, we have some wells that are showing as much as 60% of the water that we're drawing now is a younger water that has been drawn down from the superficial aquifer. This is a huge concern. We either have to move our well fields to some new locations, or we have to, shut them down entirely. Or some people have suggested, like the state of Mississippi, that we stop getting our water from our pure artesian aquifers, but instead get it from the Mississippi River. And who wants to drink Mississippi River water? Nobody in this room, I don't think. I've drank a little bit when I've fallen out of my canoe, and it's not very good. And so when we found out after the fact that they had done the supplemental environmental assessment and made this decision to move to well water, we immediately started making inquiries, and we found out that MLGW had not been really consulted on it either, that none of our local health department had been consulted beyond the well permit office. And so TVA went ahead and started applying for well permits. And unfortunately, the way that our Shelby County groundwater ordinance is written right now, it is only a single individual really at the Shelby County Health Department that reviews the need for the well, determines whether it's justified or needed, looks through the requirements, and some of these requirements are, if you can get your water from a municipal supplier, you can't have a well. If it's for cooling water or some other wasteful purpose, you have to show that you've actually gone through exercise to determine that that is, necessary, that you can't supply your water, get your water any other way. But unfortunately, there's been no oversight by our appointed Shelby County Groundwater Quality Control Board in terms of issuing the permits. And so if we were doing a land use change in Shelby County, I'm sure everybody's aware of this, you would have to go before the Land Use Control Board, and they would have to make a recommendation, yay or nay, and then that would go to an elected body, either the city council or the county commission, and they would have the final say on whether that land use change could occur, or that planned development could occur. Here in the case of our groundwater, there's no such oversight. There's no accountability to the voters in Shelby County. This is one of the things that I'm very hopeful here. Most of our county commission has expressed to me that they are willing to amend our groundwater quality control ordinance and put in place public notification, public hearings before the Groundwater Quality Control Board, and final say of the Shelby County Commission in the issuance of permits. This is a positive, for sure, that's happening here. In regards to the Tennessee Valley Authority's wells, nobody has ever appealed a permit that has been granted to a company. And there are numerous companies in Shelby County that have their own wells. Nobody has ever appealed them because there's never been any public notice of the issuance of those permits. And it says that you have to appeal them within 15 days of issuance, but how would we know to appeal a well or know that a well was happening without any kind of process of public notification? In this case, the Shelby County Health Department, we did go to the county commission, make a little bit of a stink about this, and the county commission wanted to right then say, no permit. Unfortunately, the law didn't allow them to do that. The health department heard what the county commission was saying, and so when they did decide to issue the final 2 permits, I'll back up a second, they got 1 permit in May 2016, 1 permit in June 2016, 1 permit in July 2016, and it was September when we finally went before the county commission. Well, on these final 2 permits, the health department actually took the proactive step of calling Tom Charlier up on the phone and saying, we're issuing these 2 permits, which gave me notice that they were issued, and so within 15 days I filed an appeal on those permits based on my non-lawyerly understanding of what the intent was behind the ordinance when it was first passed. And we believe this ordinance was passed in 1987. We believe that it had the best intents of protecting our groundwater into the future. Again, they stipulated no waste in the water. If you can get it from a municipal supplier, either the city of Memphis or one of the other municipalities that runs public works, then you don't get to have your own well. We think that they were looking, forward to protecting our water. My appeal was accepted. I filed it on October 5th, and they set a hearing date for October 27th. Well, October 27th was looming up on us. 4 days before that, we found out that the Shelby County Health Department had appointed a special hearing officer, hired an outside lawyer to conduct this hearing. Some of our legal team won't identify them unless they want to be identified. Talked to the special hearing officer, and he basically said, I don't know how to conduct this hearing because nobody has ever appealed a permit like this before. And I don't know what the rules are going to be like, what kind of evidence you're going to have to submit, what the process of calling witnesses and cross-examining witnesses is going to be, who can be a party to the procedure. There's nothing in the law that says that TDA has any right to be a part of the proceedings at all. These were all like weird questions that I didn't really feel like we could go forward with a hearing without knowing what the rules were. And so I filed for a continuance. At first they said that they didn't want to give me a continuance because this was costing TVA $35,000 a week to keep a drill rig on site in anticipation that they were going to be able to go ahead with things. And I found, and the law actually, with the help of one of our legal aides here, paralegal, that the way that the law read, it says that Shelby County Health Department shall not less than 30 days after an appeal, set a hearing date. So it was October 5th that I filed the appeal, it was October 27th that they set the hearing date. Boom, y'all just broke the rules. The county attorney was a little bit embarrassed that the folks in his department didn't catch that part of the county ordinance, that then made them give us an extension, a continuance on this. We set a new date of November 30th, coming up. I mean, we're moving this stuff really fast. If we were actually in a court of law, it would not move this fast. We would have time for findings, for, back and forth between all the parties, answering each other's questions. They don't want to give us that much time, because again, TVA thinks they're in a hurry to drill these wells. They're not going to start this plan until next July, so we don't understand why they're really in that big of a hurry, except for that they want to short circuit the process. So they set a hearing date of November 30th. I found out 2 days later that from when we set that all of the expert witnesses from our Groundwater Institute, or CSER now, were going to be in South America at a conference. And we thought that was kind of troublesome for our case, and so we asked for another continuance. The response to that was that the Tennessee Valley Authority hit me with a motion for dismissal, saying that I didn't have standing to challenge their well water permits. Now, that was kind of shocking to me, because I live here in Shelby County, and I drink water from the Memphis Aquifer. It seems like that gives me standing.